The principle of equal suffering under the law proposes a fundamental recalibration of how burdensome legal regimes are understood and applied. Rather than viewing equality solely through the lens of formal treatment or identical procedural rights, this concept demands parity in the distribution of negative consequences arising from restrictive statutes. When laws impose constraints on voluntary association, risk mitigation, or private ordering, those constraints must bind all citizens and groups with identical force and without exception. This universality ensures that no segment of society escapes the practical costs while others endure them, transforming selective disadvantage into shared endurance. Equal suffering under the law operates as a corrective mechanism against frameworks that claim neutrality yet produce asymmetric outcomes. Statutes advancing broad social goals frequently generate uneven lived experiences, particularly when group-level behavioral or cultural patterns interact with mandated proximity or access. By insisting on maximal and consistent enforcement, the principle eliminates de facto exemptions and compels every affected party to confront identical realities. It reframes equality not as uniform opportunity alone but as reciprocal burden sharing, where the full weight of policy trade-offs rests equally upon all. This approach carries both diagnostic and strategic value. It exposes tensions within man-made legal structures that prioritize certain objectives over others, often at the expense of natural preferences for compatibility and security. Through deliberate generalization of restraints, equal suffering functions as a forcing function for societal reassessment. If the laws deliver net benefits, universal application should demonstrate their worth. If they undermine flourishing, widespread endurance accelerates pressure for repeal or reform. The principle thus restores intellectual coherence to equality discourse by demanding genuine reciprocity in endured outcomes. Defining equal suffering under the law. Equal suffering under the law, also articulated as equality of burdens or reciprocal suffering, asserts that any statute generating significant social or personal costs must distribute those costs uniformly across all demographics and communities. It rejects partial or selective implementation that allows favored groups to avoid the full implications while others bear disproportionate weight. The principle treats burdensome rules as general instruments whose negative effects cannot legitimately be confined to subsets of the population. This universality applies with particular force to regimes restricting private preferences or imposing mandatory integration of divergent elements. The concept rests on the recognition that formal neutrality in rulemaking frequently fails to produce neutral experiences. When legal mandates intersect with observable group differences in behavior, norms, or outcomes, the resulting constraints create divergent realities despite identical wording on the books. Equal suffering addresses this by requiring rigorous, exceptionless application so that every citizen navigates the same constraints and potential frictions. It deliberately sets aside individual variation in favor of collective parity, ensuring that statistical patterns become shared national experiences rather than localized burdens. Implementation follows a straightforward logic of comprehensive rigor. Every institution, jurisdiction, and social sphere subject to the rules faces identical scrutiny and enforcement standards. Claims of disparate impact or unequal treatment trigger reciprocal demands for universal compliance. The framework maximizes visibility of policy downsides by removing exit options, creating conditions in which continuation becomes collectively unsustainable. Through this mechanism, equal suffering serves as both analytical tool and practical strategy for exposing flaws in expansive regulatory schemes. Terminological variations and conceptual expansions. Several interrelated terms illuminate different facets of equal suffering under the law. Equality of burdens focuses on parity in the weight of legal restraints rather than benefits or opportunities. Reciprocal suffering underscores the mutual character of endured consequences, preventing unilateral imposition upon particular groups. Leveling down equality draws from judicial practices that reduce advantages uniformly when equal extension proves impractical, extending the same logic to costs and limitations. These formulations maintain precision while allowing flexible application across legal domains. Mutually assured disruption captures the strategic dimension, wherein universal enforcement renders negative effects intolerable for all parties, generating endogenous pressure for change. Symmetry in sacrifice and universal application of restraints similarly emphasize the demand for unyielding generality. Each variant rejects selective leniency that permits certain coalitions to insulate themselves from realities imposed on others. Collectively, they challenge the assumption that equal treatment under law equates to equal flourishing or security, insisting instead on shared endurance of trade-offs. These conceptual expansions highlight the principle's alignment with deeper rule of law values. Generality and predictability require that laws operate as uniform instruments, not tools calibrated to serve specific interests. When statutes produce eroded trust, constrained association, or heightened friction, equal suffering demands that such outcomes become collective rather than selective. The terminology thus provides a coherent framework for critiquing and reforming regimes whose practical impacts diverge from their stated neutral intent. Logical foundations of the principle. The logical foundation of equal suffering derives from classical rule of law requirements that statutes maintain generality and avoid class-based legislation. Burdensome rules claiming legitimacy as neutral must demonstrate consistent application across all affected parties. Selective enforcement or de facto exemptions undermine this foundation, revealing the laws as instruments of asymmetric power rather than impartial justice. By demanding maximal rigor everywhere, the principle enforces intellectual consistency. Either the policies merit universal acceptance or their defects warrant collective rejection. Strategically, equal suffering functions through mutually assured disruption. Universal application ensures that advocates, policymakers, and beneficiaries confront identical constraints and outcomes as those already subject to the burdens. This reciprocity eliminates privileged distance and compels honest evaluation of net effects. Litigation and claims of inequality become symmetrical, with every group empowered to demand equivalent compliance. The resulting environment of heightened tension and reduced individual flourishing accelerates demand for fundamental reform. The principle acknowledges that existing frameworks already generate suffering through compelled interactions and restricted preferences. Extending this reality universally prevents selective flourishing and forces systemic reckoning. It operates on the premise that flawed man-made laws, when broadly and rigorously applied, expose their own incoherence. Equal suffering thus transforms potential hypocrisy into a mechanism for genuine parity, aligning legal practice more closely with the ideal of laws as general burdens borne equally by all citizens. Strategic application and enforcement mechanisms. In practice, equal suffering requires uncompromising enforcement of restrictive statutes without carve-outs or discretionary leniency. Anti-discrimination regimes, disparate impact doctrines, and related mandates must bind every context and demographic with identical force. This approach maximizes the visibility of social costs by ensuring no enclave or coalition maintains insulation. Every claim of unequal treatment triggers reciprocal demands, creating a symmetrical landscape of legal accountability and mutual constraint. The principle extends naturally to interconnected policy domains influencing social composition and interaction. Expansive frameworks shaping membership and access must carry equivalent consequences nationwide. Enforcement becomes a tool of reciprocity, where selective application invites challenges demanding universal rigor. The outcome is a legal culture in which policy trade-offs, whether in trust erosion, normative friction, or constrained liberty, distribute evenly, removing the ability of any group to externalize costs onto others. Through this strategic lens, equal suffering accelerates societal self-correction. Widespread endurance of negative effects fosters conditions under which collective preferences for ordered association and security can reassert themselves. The principle accepts intensified short-term conflict as necessary to reveal and dismantle unsustainable structures, ensuring long-term coherence through shared experience rather than asymmetric imposition. Societal implications and corrective potential. Broad application of equal suffering generates profound societal implications by making policy consequences universally tangible. When legal mandates intersect with group differences, the resulting frictions and adjustments become national rather than localized phenomena. This shared reality undermines selective narratives and compels re-evaluation of frameworks whose costs have previously remained unevenly distributed. Trust, cooperation, and voluntary ordering face identical pressures across all communities, highlighting the tension between abstract ideals and practical human tendencies. The principle restores balance to equality discourse by treating burdensome laws as collective instruments whose downsides must be borne reciprocally. It rejects partial implementation that punishes certain populations while shielding others, demanding instead full symmetry in endured restraints. Through comprehensive application, equal suffering exposes the substantive impacts of subjectively administered statutes, fostering conditions for reform grounded in genuine generality and mutual accountability. Ultimately, the concept offers a pathway toward legal and social coherence. By insisting on equal rights to suffer under restrictive regimes, it ensures that man-made laws face their logical conclusion, universal acceptance through demonstrated value or rejection through collective unsustainability. This corrective potential positions equal suffering as a principled response to frameworks that have produced uneven burdens while claiming impartiality. Historical and legal context justifying the principle. The emergence of equal suffering as a necessary corrective arises from successive layers of constitutional and statutory development that expanded membership criteria while restricting private ordering. Foundational shifts in citizenship definitions and immigration frameworks created broader incorporation of diverse elements into the polity. Later consolidations and reforms removed earlier selectivity, producing demographic transitions that interacted with anti-discrimination mandates to limit traditional preferences for association and compatibility. Reconstruction-era amendments established national standards for belonging that decoupled citizenship from prior cultural or ethnic considerations. Mid-20th century legislation further broadened entry pathways and consolidated rules into unified structures. Subsequent changes prioritized family reunification and access over earlier balancing mechanisms, generating pressures within social and residential spheres. Anti-discrimination statutes, reinforced by judicial doctrines emphasizing neutral rules with uneven outcomes, constrained proactive mitigation of resulting frictions. This historical sequence illustrates how interconnected legal developments impose burdens that necessitate reciprocal application. Equal suffering emerges as the logical response, demanding that the full weight of these frameworks apply universally until their cumulative societal impacts compel thorough reevaluation and reform. Through this comprehensive lens, the principle ensures that the consequences shaping contemporary legal and social realities rest equally upon all citizens, advancing genuine parity in both formal rights and endured outcomes. Conclusion: toward genuine parity through equal suffering under the law. Equal suffering under the law offers a coherent and principled response to the asymmetries embedded in modern restrictive legal frameworks. By demanding universal and rigorous application of burdensome statutes, the principle ensures that constraints on voluntary association, risk mitigation, and private ordering bind all citizens and groups with identical force. This universality eliminates selective exemptions and compels shared endurance of the full social, cultural, and personal costs generated by expansive anti-discrimination regimes and related policies. Rather than permitting certain segments of society to insulate themselves from practical consequences while others bear disproportionate weight, equal suffering transforms formal neutrality into genuine reciprocity of outcomes. The concept, expressed through terms such as equality of burdens, reciprocal suffering, leveling down equality, and mutually assured disruption, aligns with core rule of law values of generality and predictability. It functions strategically by creating conditions of mutual accountability in which policymakers, advocates, and beneficiaries confront identical realities. Through symmetrical enforcement and reciprocal litigation, the principle exposes tensions between stated ideals of integration and observable patterns of friction, trust erosion, and constrained flourishing. Its logical foundation rests on the insistence that man-made laws claiming impartiality must demonstrate consistent effects or face collective rejection through their own widespread unsustainability. Ultimately, equal suffering under the law restores intellectual and practical coherence to equality discourse. It acknowledges that successive constitutional and statutory developments have produced interconnected frameworks whose burdens require uniform distribution. By insisting on equal rights to endure the full weight of restrictive regimes, the principle advances a corrective pathway, one in which no group maintains privileged distance from policy trade-offs. In doing so, It fosters conditions for honest societal reassessment and potential reform grounded in mutual accountability, shared experience, and genuine parity between formal rights and endured realities. This approach offers a disciplined mechanism for addressing the deeper contradictions within contemporary legal structures while upholding the ideal that burdensome laws must apply equally to all.